case number 90044, State of Kansas v. Reginald Carr, Jr.
Mr. Chief Justice and members of the court, I'm Deborah Wilson, representing the defendant, appellant Reginald Carr. Mr. Chief Justice, I'd like to reserve 5 minutes rebuttal today.
5 minutes is granted.
This case comes before the court after Reginald Carr was convicted in the District Court of Sedgwick County, Kansas, of capital murder and sentenced to death. Reginald Carr appealed his convictions and sentences. This court affirmed his convictions of capital murder and all the associated convictions, but reversed his sentence of death. The case was then taken up by the United States Supreme Court that reversed this court's ruling on the issues that it reversed on. That left this court with some unanswered questions about his penalty, and we're before the court today pursuant to supplemental briefing on those questions that had been left unanswered. The jury that decided Reginald Carr should die for the crime of capital murder never heard Reginald Carr say, "I didn't do it, and I can explain the evidence against me." Even though he wanted to do so, he was ready to do so, and he had the right to do so. Today, the state of Kansas will ask this court to approve the execution of Reginald Carr after having succeeded in preventing him from presenting his defense to the jury. We contend today that due process requires a defendant be allowed the opportunity to present his defense to the jury before the state executes him. Reginald Carr's jury saw a man who for weeks in the courtroom, in the face of accusations by the prosecutor and by his own brother that he had committed horrible, violent acts, sit silently. And the jury that never heard his denials and never heard his explanations was not instructed in determining Reginald Carr's penalty. You may draw no adverse inference from his silence during these proceedings. And of course, that jury was ignorant of the fact that that silence had been forced on him because of the trial court's erroneous rulings that left him with a defense that left him in the position that if he had testified, complying with the trial court's orders, he would not have been able to give the jury any information that was beneficial to his defense.
And which orders are you referencing exactly?
The trial court's order that he could not refer to Jonathan's companion, who he saw and interacted with on the night of the crimes, and the order that he could not tell the jury any of the statements that Jonathan related to him about the crimes committed by Jonathan and his companion. That's the third-party evidence rule in the hearsay issue. This court's already determined on those issues that the trial judge erroneously kept Reginald Carr in his seat, off the witness stand, and silent during these proceedings. And although this court found that those errors did not affect the jury's verdict of guilt, this court should not find that had Reginald Carr actually defended himself, it would not have mattered as to his penalty. Reginald Carr's inability to defend himself in the guilt phase deprived him of the mitigating circumstance of residual doubt. Courts have recognized, at this court as well, in this decision, that residual doubt as to the defendant's guilt is a valid mitigating circumstance, and the state hasn't argued otherwise today. Studies of actual capital juries show that residual doubt may be the most important mitigating circumstance because studies show that it is in that gap between proof beyond a reasonable doubt and proof beyond all doubt that juries often find their reason to impose life without parole instead of death. Reginald Carr's inability to defend himself in the face of the state's accusations and his brother's accusations removed all doubt that could have been engendered by the fact that no DNA evidence placed Reginald at the Birchwood address, while Jonathan's DNA was found in multiple areas at the crime scene, the fact that both Jonathan and Reginald were at the preliminary hearing, clearly identified as the defendants, but the surviving victim, when asked, recognized Jonathan, and only Jonathan, as one of the intruders at Birchwood. The fact that the surviving victim testified at trial she identified Reginald Carr in a photographic array that didn't contain his photograph. And finally, the fact that the surviving victim testified that Reginald was the intruder who ejaculated in her mouth when it was Jonathan's DNA, and only Jonathan's DNA, that was found on the oral swab taken from her. If Reginald had taken the witness stand, denied the charges against him, and related his encounter with Jonathan and Jonathan's companion after the crimes, as well as Jonathan's statements that related the events at the Birchwood address and in the soccer field, had he been able to explain his appearance at the crime scene after the fact, as well as his possession of the stolen property, the problems with the eyewitness identification and the DNA evidence in this case would be much harder to brush aside and could have engendered sufficient residual doubt to result in a life sentence. But instead, he sat silently in the courtroom because of the trial court's erroneous evidentiary rulings. This error was then compounded by the trial court's erroneous denial of his motion to sever his trial from that of his brother. Remember, Jonathan had a mountain of evidence against him, and during the guilt phase, rather than defend himself, he put his energies into making sure that Reginald was convicted as well, so that he could point at Reginald during the penalty phase as being the more culpable of the two. During the guilt phase closing, it was Jonathan, not the state, that claimed that Reginald owned and disposed of the murder weapon. It was Jonathan, not the state, that claimed that there was only one shooter in the soccer field, and that shooter was Reginald. It was Jonathan who argued that Reginald had not produced an alibi. That, of course, is a burden-shifting argument that no prosecutor is allowed to make, but no problem in this case because Jonathan made the argument for them. The joint trial in this case let the state and Jonathan Carr gang up on Reginald Carr, while the trial court's mistakes of law kept him silent and defenseless while he was being attacked on two fronts. I cited some United States Supreme Court due process cases to this court in which the court held that a defendant's sentence of death must be reversed because a defendant was not allowed to deny, explain, or refute evidence used against him in imposing a sentence of death. I would suggest that the due process violations of Gardner, Simmons, and Skipper pale in comparison to this one. Gardner concerned information that was in a PSI that the defendant didn't have access to. Simmons concerned concealing from the jury the fact that the defendant would never be eligible for parole. And Skipper involved the jury not hearing about the defendant's good behavior in prison. Those are all pieces of a mitigation case that certainly could have some bearing on the jury's sentencing decision. But in this case, the state's entire case for death was based on the particular facts of these crimes, facts that Reginald Carr had a defense to, that he was wrongfully in error, denied his ability to present to the jury. If the facts of Gardner, Simmons, and Skipper required reversal of the death sentence in those cases, these facts certainly do. I have also argued, however, that this court doesn't have to go as far as the due process clause of the federal Constitution to reverse due to the trial court's errors in this case. This court can do so under state law. This court's already found state law error in the court's failure to sever the guilt phase trials. This court has already found state law error in the trial court's evidentiary rulings that prevented Reginald from presenting his defense. We contend those can't be considered harmless as to the penalty phase because first, under state law, Reginald was denied the mitigating circumstance of residual doubt under KSA 216625, and because Jonathan's antagonistic defense worked in the penalty phase as a non-statutory aggravating circumstance against him, which is not allowed under KSA 216624. And I would urge this court to take that state law route and reverse his penalty for those reasons. We've argued that your finding of error in the joint penalty phase trial, the finding that the United States Supreme Court reversed on, is sustainable without reference to the Eighth Amendment, because when finding error in the joint penalty phase trial, this court applied the same state law standards that it has for over 40 years.
You're talking about severance again now.
In severance,
Okay.
this time in the joint penalty phase
Yes,
trial.
I'm following. Thank you.
First-
What role does the, I guess, dictum or the editorializing from the Supreme Court play in our decision?
I would say none. You call it dictum, and that's what we called it in our brief. Sometimes I refer to it as gratuitous, but the end result is the same. This was an issue that was not before the United States Supreme Court. The United States Supreme Court isn't bound to follow that, and you're not bound to follow it either because it's dicta. But another reason...
And in fact, they will not review
No.
that finding here, correct?
That's correct. They won't review any sort of finding of error on state law grounds. And additionally, when the court found, when it went ahead and said, well, we don't think had he been allowed to confront, had he been allowed confrontation rights in the penalty phase, that it wouldn't have mattered anyway. When they did that, they weren't considering the effect of cumulative error in the case because they weren't aware of all the other errors that this court had found.
That's one bit of editorializing. There was some other throughout, including in the severance section of the opinion. I think that's what you were referring to, weren't you, Justice Johnson? Okay. I'd like to direct you to another issue just because I don't want your time to expire and I not get a chance to ask you about it, and then you can continue. How does our fairly new Sherman case on prosecutorial error affect you here? I know you made prosecutorial misconduct
Correct.
Challenges or advanced challenges in the penalty phase, and we didn't really reach them because
Right.
at the time it looked like there was going to be a new penalty phase hearing. So could you address Sherman for us, please?
We've addressed Sherman, and the state has addressed Sherman in our supplemental briefs as well. And I think that the Sherman decision actually made our burden a little lighter because now we're not required to prove any kind of intention, any kind of malice, I guess I'll put it under that. We don't have to show malice to show prosecutorial error. Instead, the focus is really on if the prosecution has made a misstep in their argument, the focus is really on the result and how it affected the fairness of the trial. And I don't believe that affects, I'm sorry, Justice Johnson, go ahead.
Is that, you said, affected the result and the fairness of the trial?
Mm-hmm.
And what we're dealing with here is the position that the evidence was so overwhelming that it wouldn't have changed the verdict. And we talked about this the last time you were here. The difference between a fair trial is a really, really guilty defendant entitled to a fair trial under the Constitution, because it doesn't say it applies only to people that are not really, really guilty. So where do we fit that in here when those two things are not always in step, if you understand what I'm saying?
I do, and as tempted as I am to say that if the trial isn't fair because of prosecutorial error, then even if the defendant is, even if that unfairness didn't affect the verdict, we should still win. I'm tempted to say that, but I think I have to go with the harder row to hoe here and argue that it actually did affect the outcome of the verdict.
Well, this would be constitutional, wouldn't it?
Mm-hmm.
And so it's a reasonable possibility that it could affect.
That's
right?
correct.
Not that they would have. We don't have to find they would have found, just a reasonable possibility.
Yes, and plus we have to fold in the fact that we're no longer dealing with the guilt phase, where you can make a good assessment of here was the evidence, here was the error really didn't affect the way the jury assessed the evidence. When we come to the penalty phase, we're talking about value judgments. And so I think it's much harder to say certain prosecutorial error didn't affect value judgments made by the jurors. And in this case, the prosecutorial error, we contend, did affect the way the jury looked at the mitigation case and affected their value judgment. Reginald Carr presented evidence of a dysfunctional childhood that was marred with parental abuse, neglect, and abandonment. The state, in response, didn't argue to the jury, well, Reginald's claims of childhood abuse and neglect aren't true. The state, in response, didn't argue to the jury, well, they might be true, but they should be assigned minimal weight when you look at the horrendous circumstances of these crimes. Instead, the rebuttal to Reginald's mitigation case was this: how dare he tell you these things? This evidence is shameful, it is despicable, and it is insulting to you as jurors and to anyone else who has ever been abused. These arguments reflect maybe not malice, but they reflect a complete misunderstanding of the role of mitigation in a capital case. And these arguments were repeated throughout the course of closing argument, and they were repeated with great vigor, creating the great danger that this view, this misunderstanding of the role of mitigation evidence was also accepted by the jurors in this case. So I believe that Sherman actually does make our task a little easier because we don't have to show bad faith. And I believe we have a record that shows that the jurors' value judgments about whether they should extend mercy or not were probably affected by this idea that his mitigation case was shameful, despicable, and insulting.
Counsel, I just need to confirm with you my review of the briefs and the arguments on the no adverse inference instruction. Your claim is based entirely on the Fifth Amendment and not the state constitutional Section 10, is that right?
Correct.
Okay.
And this court, of course, did not find whether Reginald was entitled under the Fifth Amendment when he asked for a no adverse inference instruction in the penalty phase. I'm asking this court to make that determination now. In death penalty cases, there's no longer any legal rationale for pretending that the penalty phase of a capital trial is anything less than a full criminal trial. In the language of Apprendi, on the greater offense that allows the imposition of the enhanced punishment, in this case, death instead of life without parole. That was what the United States Supreme Court held in Apprendi. It was adopted for capital cases in the Ring case, and I think Hurst underlines the fact that not only are aggravating circumstances an element, but the weighing portion is an element also. And this court, in its most recent Kleypas decision, recognized that the penalty phase is in fact a trial on the issue of punishment. Since it is a criminal trial on the greater offense that allows an enhanced punishment, Carter versus Kentucky and Estelle versus Smith support the position that Reginald was entitled to that no adverse inference instruction. Carter supports the position that this error might require automatic reversal. However, If this court decides to apply a harmless error analysis to that question, remember, Reginald was silent not because he didn't have anything to say. Reginald was silent because the trial court's erroneous rulings left him without...
How do you know that? Was there a proffer given to the court that my client's not going to testify because of? Was it that specific? Aren't you just projecting that's why he didn't testify, or did he give a statement as to why I'm not going to testify is because I can't get into this particular area of inquiry? Was that ever offered to the court?
No, that statement wasn't made, but I'd like to read to you some portions of your opinion with regard to that question. This court was discussing the question of whether this was a denial of his right to present a defense, or if it was a denial of his right to testify. And I wrote this down.
Well, I'm talking about in this particular case.
Right, in this particular case. This was in the first decision. Well, let's see. Well, what this court stated when it was talking about whether this was a denial of his right to present his defense or his right to testify, the court stated that that Reginald made the decision to not testify in the wake of the trial court's rulings, and the court noted that the trial court's rulings left him without the ability to testify to anything beneficial to his defense.
So we made a finding of fact in our opinion on that. That would seem to not fit what appellate courts do.
Take a look at page 210 and 211 of the opinion. I can't find the actual statement that I had written down, but it was to that effect, that the trial court's rulings left him without the ability to testify to anything beneficial, anything that would benefit his defense. This court found that the trial court's incorrect evidentiary rulings didn't merely prevent him from presenting some evidence integral to his defense. Those rulings kept him from presenting it at all. On page 210 of this opinion, this court stated, "We have already determined that Arkar's proffered evidence was relevant and admissible. It was not merely integral to his defense, it was his defense." That's the end of the quote. The only vehicle for Reginald Carr to answer and explain the state's evidence against him was his own testimony. The judge limited his testimony in such a way that the prosecution would have been able to drive trucks through it. The incorrect evidentiary rulings just butchered his defense, and had he taken the witness stand and testified, his testimony would have made him appear more rather than less guilty. And then the court did go on to say, around 210 or 211 of this opinion, that he was deprived of the ability to testify as to anything beneficial to his defense. So he would have been left with a counter-narrative that was completely full of holes. In my remaining time, I'd like to address the cumulative error in this case. Just consider this. Reginald Carr could have proffered residual doubt, possibly the most powerful mitigating circumstance that there is, had he not been silenced by the trial court's erroneous rulings, and had he not been forced to stand trial in both the guilt and penalty phases with two prosecutors against him. His innocence was his mitigation, and the jury didn't get to hear about it. I've argued that you shouldn't engage in a harmless error analysis, but if you do, Reginald Carr's case presents an absolute quagmire. To reach a finding of harmless error, this court would be required to say, had he been allowed to defend himself? Had his guilt phase been separate without Jonathan actively prosecuting him? Had the penalty phase been separate and untainted by Jonathan's mitigation case? Had the court given a no adverse inference instruction? Had the court correctly instructed jurors on the burden of proof for mitigation evidence? Had the jury not heard testimonial hearsay that painted him as a career criminal who would pose a threat to corrections officers? And had the prosecutor not improperly argued that his evidence of childhood abuse and neglect was shameful and despicable and insulting, the jury still would have voted to sentence him to death. To reach that conclusion, this court would almost be saying, for these convictions, we do have an automatic death penalty. This court would have to be willing to say, in this case, there can be only one sentence, a sentence of death. I do not believe this court should find there was no mitigation in this case that would have mattered. This court should not find that absent all this error and prejudice, Reginald, no person on that jury would have decided to extend mercy. I urge you to find instead that Reginald Carr's sentence of death cannot stand under the considerable weight of the cumulative error in this case, the most profound being the trial court's decisions that left him facing two prosecutors and silent and defenseless when he was on trial for his life.
Does that conclude your presentation?
Yes, Your Honor.
Do we have any more questions?
I do, please. What's the role of the errors in the guilt phase when we accumulate in the penalty? I didn't hear you say anything about the voir dire or anything. You said you're talking about the jurors granting mercy or the residual doubt. So do any errors in selecting the jury factor into that analysis? Or you understand what I'm trying to ask you here?
I understand what you're trying to ask. That's not an issue we raised because I think all those questions were put to bed by this court's first opinion.
Any further questions? Thank you, counsel.
Good morning. May it please the court. The state's position in this case is that there was no individual error that would cause this court to reverse the death penalty verdict, and there's no cumulative error that would cause reversal as well. The defense has argued that the state impeded his ability to argue residual doubt or for the jury to consider residual doubt as a factor in mitigation in this case. The problem with that argument is that that wasn't what occurred or was even requested at the penalty phase in this case. Reginald Carr's defense was not that there was residual doubt. In fact, his attorney embraced it, the guilt in this case. He talked about and admitted to the jury that all these things occurred, but they were going to present reasons why death should not be given. Not one time, not even in the instructions in this case, was residual doubt presented as one of the mitigating factors. Granted, the instruction indicated that the jury could consider anything else or any other factor, but the defense attorney in that case, not once, not an opening statement in the penalty phase, not in the closing statements of the penalty phase, did that attorney indicate anything other than the fact that Reginald Carr had committed these offenses and he had done so, and that there was just asking the jury, please find a reason to either sympathize or give mercy to this man because there was some good left in his life. For that reason alone, we would ask that you reject the residual doubt aspect of this case for reversal. Secondly, if this court doesn't go with that argument by the state, we would ask that you find that the errors that occurred in this case didn't undermine his ability to argue residual doubt. If you look at the penalty phase as a whole, including the evidentiary portion of it, and if you look at the closing argument aspect of it, it's clear that none of these errors that are complained about today had any effect on counsel's ability or Reginald Carr's ability to argue his case in mitigation. Was this a perfect trial? Probably not. No trial is. And I would urge this court to reject the notion that a perfect trial is required just because this is a death case.
Mr. Loudon?
Yes, ma'am.
You just said that nothing that occurred impaired the ability to argue the case in mitigation. So I'd like you to address specifically the statements by the prosecutor during closing argument that opposing counsel just referred to about the mitigation evidence being despicable, the advancement of the mitigation evidence being despicable or insulting, those sorts of things, kind of the more heated aspects.
Agreed. Again, with regard to that, I don't agree with counsel's characterization of the closing statements and how they were used. I think if you go back in, were some of these words used? Were the words insult used? Yes. Was the word blame used? Yes. But if you look at the argument as a whole, the argument focused on the ability of the jury to find mitigation and to weigh mitigation against aggravating factors and make a decision based on that. An attorney, a prosecutor, can make impassioned arguments to the jury. When we look back on those arguments, at times we're absolutely, well, for instance, when I first read that argument, I'd read counsel's brief and the way that it was characterized. So I had something in my mind, and when I first read the argument, I said, okay, this, the court is not going to appreciate this argument very much. I went back and read that argument a couple times in the context of just with an open mind about it. When I read that argument, what I found was the argument wasn't, I can't remember the word she used, but littered with these dispersions against the evidence or the mitigation. Most of it was a balanced argument concerning why the mitigation shouldn't sway the jury to a life sentence versus death. The complaints about the insults and the blame, for instance, they're contained in a couple sentences, 2 or 3 sentences, in a very small part of the argument. And if you look at that, as we look back on it now, would you say perhaps that wasn't the best word choice? But really the question comes down to not whether this case could have been argued better. The question is, what impact did it have? And we have to look at that and we say, how the state's position is, how could that have impacted the jury's decision-making process? If the jury was, if each individual juror was inclined to find mercy, it wasn't going to turn on whether the prosecutor characterized it in some other manner. I think that not only doesn't give credit to the jury and their ability to follow the directives of the court as far as the instructions are concerned, but there was nothing about those comments that stopped the jury from making, or each individual juror from making a decision on their own. And that's my point. We didn't impede the ability to argue mitigation as it's now addressed by counsel.
Counsel,
Does that answer your question? I'm sorry.
It did.
Thank
just so I'm clear, are you saying that it was error or not error by the prosecutor to make those comments?
I think the allegation, Your Honor, that each of those comments were error, I think that is incorrect. I think this court should go through and look at each one of those and determine whether that was error or not. I think the most problematic ones, in all honesty to the court, are the ones regarding the blame and the insult commentary. I think the other comments that were made, I think if you look at it in context and how the arguments were made, I don't think they were error at all. The blame argument and the insult argument in the closing argument, I think that's a closer call.
While we're on the theme of fessing up a little bit on some of these problems, my biggest problem with this case has been that the problems that are presented are almost completely self-inflicted by the state. The big one being the objection to severance, and I think I understand the state's position from the last time, so I'm not asking you about that. But why in the world would you object to the no adverse inference instruction, given its controversy across the country on whether it should or should not be in there? I can't understand it from the state's perspective, why you would, that almost is a throwaway, it seems to me, from your perspective.
Again, Your Honor, I would go back to could it have been done better, or could there have been more comments made? And I would submit to you in this instance, the request for that instruction was based upon a PIC instruction, which talked about the defendant's right to remain silent and that you couldn't use that against him to prove guilt. Factually and legally, that instruction per se was irrelevant and didn't apply to this case.
Why?
The penalty phase has nothing to do with guilt. Nothing.
There are a lot of courts, though, that disagree with that. I mean, I'll grant you that the U.S. Supreme Court hasn't nailed that one down. I'll grant you that. But there's a lot of discussion in the case law across the country that has, prior to this case, that had reversed convictions simply because of the failure to give that instruction, and then kind of the speculation that occurs about what the jury may or may not have been thinking because the defendant didn't testify. So why walk into that trap?
Yeah, I was not there. I don't understand why. But what I can tell you is the instruction that was requested and was not followed up on was not appropriate. You couldn't give the instruction you gave because it makes no sense. The jury already found the defendants guilty.
So you're saying that because the instruction that was proposed used the phrase guilt, that just automatically it wasn't appropriate, even though it'd be real easy to change the word guilt to penalty phase.
Well, that's true, but nobody suggested otherwise. But I would also say this: I'm not saying that the defendant didn't have the Fifth Amendment right against self-incrimination. I'm not saying that at all. And I don't. If the defendant cites to the White versus Woodall case for the proposition that there is some merit to the notion that such an instruction should be given. She cites to the dissent in that case where three justices indicated that, of the Supreme Court indicated that such an instruction should have been given in that case. And I understand that it was a federal habeas question regarding the Supreme Court ultimately found in White versus Woodall that the law wasn't settled on that aspect of federal law, whether that instruction had to be given. So, I understand that you're saying that there is a split of authority here, but I don't think in this instance that drives the question here.
You risk a finding of error because of a
Absolutely.
split of authority. So you risk that. And so then you're kind of leaving yourself with, well, we'll keep it out and hope, and then maybe we'll be able to convince somebody it's harmless on appeal. I mean, isn't that really what we're down to here?
Well, we're down to the harmlessness of the issue as long as you're presuming that he had a right to the instruction.
And you're not conceding that.
I am not conceding that, no. And especially as requested. I mean, we are talking about, they requested a certain instruction and the court said it wasn't appropriate or wouldn't give it.
Then don't you run into our rule that we can consider the error in a death penalty case even if it wasn't perfectly preserved below? I mean, you're making kind of a preservation argument, aren't
No,
you?
I'm not. No, not a preservation argument. I'm making an argument that is, there has been at this point in time no instruction presented to this court, to the trial court. What was the instruction that he was proposing that was appropriate? The one he proposed was not appropriate.
It could still, however, be error to give an instruction that was not requested. It would just change our standard of review, right?
Well, possibly, but even to this point, we don't have any proposed language of any instruction that would have worked or that we're going to attack. I don't have anything to defend at this point in time. The only one that I have to defend or to argue against is the instruction requested, and that was pursuant to the PIC instruction.
Well, but the defendants argued on appeal that he should have gotten a no adverse inference instruction.
And under what wording, Your Honor? And I don't mean to be glib about that, but my confusion lies in this.
I understand your position that you're stuck with not having anything to argue against, but I'm asking, I guess, the more theoretical question, which is it error? Assuming that the wording had been presented, we want an instruction that says no adverse inference from the defendant's silence during the penalty phase. Would it be error for the court not to give that instruction?
Again, I think it depends on why you're asking. Two things. It's clear from United States Supreme Court law, and even this court to a certain extent, that there is a difference between the guilt phase and the penalty phase. Within the penalty phase itself, there's even a difference. We have the evidence that supports the aggravating factors. We have evidence that would support the mitigating factors. Does he want the Fifth Amendment right? Does he want the no adverse instruction? Does he want it for the first part of the test? Does he want it for the second part of the test?
Could you repeat that one more time for me?
Where does he want the instruction to apply?
In guilt or penalty? Is
In
that what you're
the selection phase of the penalty.
Oh, selection and narrowing?
Right.
Okay.
So does he want it and have the jury apply it to just only the first part, that you cannot construe my silence against me when determining what the aggravating factors are? Or does he want it to be, I don't want you to consider my silence when you're considering my mitigating factors? I don't think it's so clear that if he's asking in the second part especially, whether he has that right to do so. He's asking for mercy from the court. So what does the right apply to? The argument has not been made sufficiently, I would submit, in this case.
Is there any part of this consideration that in the guilt phase, the adverse inference instruction was given, I believe? Isn't that correct?
That's correct, Your Honor.
And would there be maybe part of the calculus would be that the jury understands its role from that instruction given in the guilt phase, and perhaps that would be a part of the consideration, at least part of their understanding of the role that they have, is that there is no adverse inference that can be given. in this context, or would that not be a part of the calculus?
Outside of harmless error analysis, you mean?
Yeah.
I think it can be under the current law. And you have to ask, again, why is there a difference between the guilt phase and the penalty phase? The decision-making process is different, and why are you, what is the goal? So to the extent that that goal is different than the guilt phase, I do think that there is no place for it. However, I would be remiss if I didn't at least acknowledge that if there were a place for it, it would be toward the aggravating factors and not the mitigating factors. But I think we're a step short from any decision saying that it must be required, especially in a case where all the evidence has already come in, and all the state has done is say, here's the evidence on aggravating factors. We're going to present to you that everything that occurred at the jury trial. What place that instruction has under that scenario, I can't think of it. I don't know how that would have any bearing on what the jury's decision is. And again, this doesn't have anything to do with whether the defendant has the Fifth Amendment right not to say anything. I'm not saying that. But I'm not sure that he's entitled to instruction indicating to the jury that that's still his right. But
Mr. Loudon, could I move you to a different subject if you're about done with that?
Could I simply say that I think it's harmless error
Okay.
if you do find? I don't think it's a structural error issue.
Okay.
Before we leave that, can I
Sure.
ask him something along that line?
Go ahead.
Taking you back to not entitled to a perfect trial, even in a death penalty case. So is that your acknowledgement that we do have case law that says in a death penalty case we have heightened scrutiny, or if you don't want to use that term, heightened reliability, that we have to apply?
I think it depends on the question that you're asking. I think this court has already found, in some respects, at least with regard to, I think it was
Well, the
P5,
bottom
I
line,
think you found that there wasn't a heightened reliability.
well, bottom line, we have heightened reliability applies to a death penalty case, correct?
As a general matter, I would say yes.
And the heightened reliability is that we need to be more convinced of the appropriateness of the death penalty, is the whole purpose of that language. And that's a language that comes from the U.S. Supreme Court, that procedures that impact the reliability of the death penalty are not to be used. I think that's kind of the language that's in some precedent. And conceding that, how would that impact this conversation we're having about the no adverse inference instruction, not giving that? Why isn't that a procedure that impacts on the reliability of the verdict?
Two things. Again, I don't concede that the instruction should have been given, but the notion that harmless error analysis doesn't apply, I don't think that applies in this situation. Guilt versus penalty, two different things. I can't stand here and say that if the decision not to give the instruction was made in the guilt phase, that we wouldn't have more of a problem. But the instruction talks about in reference to guilt, and I think the penalty aspect of that is different. It doesn't diminish.
If the language had been changed to account for the fact that they were in the penalty phase, the language of the suggested instruction, then what would you be arguing? We're just trying to get you to argue in a more general manner and not rely entirely on their failure to change the language when they requested the instruction.
Well, again, I think it's difficult. The last time I was before this court, one of the arguments I had concerned before you can nitpick, or that's a horrible word, before you can start analyzing whether reversal should occur, you must first analyze whether a right even exists. And here, it's not so clear whether that right exists. And I don't have any language right now that says this is what I'm arguing against. And again, this goes to, does he have the right to remain silent only as to the first part of the selection process as far as the aggravating factors are concerned, or is he trying to assert the right on the second aspect of that on mitigation?
And tell me again, what difference does that make? That you're on mitigation or aggravators? What difference does that make?
His right
what's
is
the possible ramification of that distinction?
his right is against self-incrimination. Okay? So when we're talking about the mitigation phase, we're not talking about trampling on his right to mitigation or against self-incrimination in the case.
Okay. Because
And
the mitigation case is his case, in essence, is what you're arguing.
Yes,
Okay,
Your Honor.
I'm following you.
yeah. And then especially on the aggravating portion of it as well. It was already conceded in this case that he had done these crimes. So again, what impact is that having? The failure to give the instruction, what impact did it have on this case? Are we saying that under every circumstance, if this instruction, if appropriate, is not given, that that's automatic reversal? And that's why I say there's a difference between the guilt phase, the penalty phase, and how that instruction, whether it's even appropriate in this to give.
Was there a concession of guilt or a concession that the jury had reached a verdict of guilt?
There was an absolute concession of guilt multiple times where his attorney stopped short of, he said, we admit this is what Reginald Carr did. We, in paraphrasing, we own it, we know it. The only question is what happened to this man to make him do these things to these people in this case? There is not one hint, there is not one argument that he's trying to make a residual doubt request.
Did the state ever advance any kind of argument or even innuendo that Mr. Carr's silence could be construed against him in any kind of way?
In the penalty phase, Ron?
Yes. In the
No.
Which is, this instruction seems to presume that the jury would construe silence against the defendant, but nothing from the state could be construed to have promoted that thought or that idea.
No, Your Honor. No. And I think my difficulty here is I don't want to bleed the two things together as to whether, first of all, it was error and whether it was harmless. But going to Justice Rosen's inquiry concerning does some of these realities of the penalty phase, do they factor into whether the decision to give such an instruction is appropriate?
You mean the guilt phase? The fact that it was given in the guilt phase has an impact on harmlessness in the penalty phase?
Not so much that. I think that bears on harmlessness more than anything. Okay. But I do think that just the reason why you're there
I see what you're saying.
Makes an impact on whether he has a right to even receive it. And what I'm imploring this court not to do is to jump to the notion that the right absolutely exists without identifying how that right exists and where that comes from.
What it has an impact on.
Correct.
Yeah. Can we move to that other subject?
Yes, ma'am.
It's severance. And I want to talk about, I think we can both acknowledge that we had the majority of the court, it was split, that's a 6-1 vote, as I recall, that there was a severance error in the guilt phase based on state law, and there was a severance error in the penalty phase based on federal law. And the severance error in the penalty phase based on federal law was one of the issues on which we were reversed by the U.S. Supreme Court. Okay, so that's the status. And the defendants are arguing that just as much as there was a state law error in the guilt phase, there was the same error in the penalty phase, a state law error. And so we've talked a little bit back and forth on some other questions about how do the rulings in the guilt phase or the facts of the guilt phase affect the decisions we make in the penalty phase. I'd like you to address that on severance in particular. I think your opponents have made the argument that an error is an error is an error as far as severance goes. And we already found state law error in the guilt phase. Why would that not carry over to the penalty phase?
A clarifying question, Your Honor. My
Sure.
understanding is that this court's decision on severance was based on federal law
In the penalty phase.
in the penalty phase.
But in the guilt phase, it was based on state law.
Or,
It was an evaluation of the state law criteria.
okay.
And so if in fact we found that there was a state law error in the guilt phase before, why does that not carry over to the penalty phase as well? The state law decision, is there a reason it would not? I just want to understand your position on that.
As far as a factor to be determined within the confines of the cumulative error argument? Or by itself?
Not exactly. I mean, it could have a role on that, on cumulative error for the whole case, I suppose. But I'm not really asking that question. I'm just asking if we had a state law error and failure to sever in the guilt phase, why does not, what scrubbed the case of that error once it reached the penalty phase? That's what I'm trying to get to.
I think it goes back to, again, I think there needs to be a differentiation between the guilt phase and the penalty phase because the processes and the reasons for having those things are two different things. And I think the U.S. Supreme Court absolutely nailed why severance was not a problem under the federal Constitution. And I don't see how that ruling and the logic behind it is not worthy of being followed, not as a mandate, but as a matter of reason on the state law basis. I think the impact of why you're there at that second stage makes a difference in the analysis. And I think that any error that would have occurred in the guilt phase, I think that has to be considered separately and not
Why would
grafted.
it be less, how would it be less harmful? In the guilt phase, we have pretty defined parameters. It's more an objective determination. Are these elements, have they been proved? In the sentencing phase, it's more subjective. Should I grace this defendant with mercy? And given that it's more subjective, why isn't the harm inherent in antagonistic defenses more harmful in that context? Are you understanding what I'm saying? I mean, if it's either yes or no, that's one thing. And if it's what do you subjectively think is most appropriate here, that makes it more damning when you have a co-defendant dogpiling on the other one with regard to culpability. Does that make any sense to you, what I'm saying here?
It does, and I think the difference is, again, when we're talking about is somebody guilty of something and what was your role in that versus asking somebody to make an argument in mitigation or consider something in mitigation when one brother seemingly is saying, I'm the way I am because of the influences of my older brother. I mean, is that kind of what you're referring to, I think? And I do think that makes a difference because they're not being measured against themselves or they're looked at individually. I know there's been an argument in these cases that somehow we were grouping everybody together and trying to put them into the same pot, but I think if you look at everything that occurred in the penalty phase, you'll see that we were asking for an individual decision on each person. So I guess I have trouble saying that the goals of at the guilt phase aren't different than the goals at the penalty phase, and that there isn't, just because there may be a different focus as far as, are you going to find mercy on me? Are you going to sympathize with me? I don't know that that subjective nature of the hearing itself has any greater gravity than the gravity in the penalty, in the guilt phase. I don't know if I answered your question, but I guess I just don't see how these things were more important in the penalty phase than they were in the guilt phase.
I guess I was trying to get you to focus on just an as important argument, which is, I think, more what your opponents have been making, that it was every bit as important in the penalty phase. And I think my colleague suggested that perhaps even more important because of the nature of the jury's charge.
Well, I mean, and I see that I'm out of time. May I, Chief Justice?
Certainly.
One of the difficulties here is, and some of my hesitancy comes from asking a general question when I am absolutely not agreeing that error occurred in the penalty phase in all aspects, and that I don't agree that the error occurred individually in the penalty phase aspect of things. So when I'm up here, I think each individual error that's been alleged in this case is subject to harmless error analysis in the state's argument. And when we go to the cumulative error arguments, I think that some of that reasoning has to come forward with it and say, instead of making a quantitative argument that we had 10 errors, so there must be a problem with the penalty phase, versus a qualitative argument. And I think this court recognizes that, because even in the first opinion, when it came down to determining whether there was cumulative error in the guilt phase, this court disregarded some of the errors that were made in making its ruling. And some of my hesitancy today is I feel like I'm being asked a question without being asked as a whole, without asking what some of the pieces are that formulate this aspect of cumulative error in the penalty phase. Because the defense and I certainly disagree what was error in this case. I mean, prime example is the Dr. Reedy or the Dr. Preston and Dr. Pay argument. We disagree as to whether that was error. This court has already, I think, alluded to the fact they believe that was error not to allow the SIR rebuttal in the case. There's the confrontation issue, which the state argues that this court should not reach that and cannot reach that argument. But with regard to Dr. Preston, could he refer to, or Dr. Pay, could he refer to the other three experts? Again, I don't think that was error. And I think if it was error, that it was harmless. So I don't think that any of those things should go into the calculus when we say, was there absolutely a cumulative error in this case that requires reversal? I think that those things should be excluded.
Okay.
Do we have any further questions? Council's out of time. Do you think you need about 60 seconds to wrap up, or do you think you've made your points?
I would like the time, Your Honor. Thank you.
Very well.
This case is about perspective. And part of the perspective is, how much are we going to trust juries in these cases? The state would submit that in these cases, the jury can be trusted. The jury was instructed. I heard counsel argue about non-statutory aggravating factors. It's quite clear that we can't presume that they considered it for that reason. So without that foundation, the argument that there was a non-statutory aggravating factor concerning the no adverse inference instruction, for instance, it doesn't hold water. the notion that he was somehow deprived of making an argument in mitigation in this case. It's false. Even though we restricted the SIR rebuttal, even though 3 experts were allowed to stand in the back and wave to the jury, at the time that was an error. It flat out was not error at the time because we weren't required. We had a lesser burden, a lesser standard for sentencing proceedings, so we were permitted to present the ability for the defense to rebut, and they didn't do that. So, and then when they argued their case, they were able to argue their case through Mitchell Waltersdorf, Dr. Reedy. If you go look at the closing arguments, nothing impaired their ability to present their mitigation case. So we would ask this court to find that there is no cumulative error in this case that would require reversal. There's no individual error that would require reversal because it would be harmless. Thank you.
Thank you, counsel. You reserve 5 minutes for rebuttal.
Well, I borrowed Mr. Nelson's glasses, and I was able to find the quote that I was searching for in vain in the earlier part of my argument. On page 210 of this court's opinion, here's what this court said about Reginald's ability to testify in this case. Our car urges us to treat the violation of his right to present a defense, particularly given its effective preclusion of his ability to testify to anything useful to the defense, as structural error that is automatically reversible. Then this court noted that his decision to testify was made, quoting from the decision, after consulting with counsel in the wake of the trial judge's rulings. So this court didn't say that the trial court came out and violated his right to testify, but instead what the court said is whether it was his right to present a defense or his right to testify, we can analyze this question for harmless error. I was surprised by counsel's assertions that defense counsel had conceded guilt in the penalty phase. I don't remember any statements to the effect of he's guilty, he did it, we admit he did it. I do recall statements to the effect of we accept your verdict. I could be wrong about what's in the record on appeal, but I would note that if there had been citations in the state's brief to these alleged admissions of guilt, it would have been helpful to all of us in analyzing that question. Now, should Reginald Carr have argued residual doubt in the penalty phase after not being able to present a defense in the guilt phase? Let's assume for a minute that Reginald Carr sought and received permission to give the evidence that he wasn't allowed to give during the guilt phase, during the penalty phase. That would have resulted in some very confused jurors in this case. The jurors had already found him guilty. They would have wondered why, after finding him guilty, he was now defending himself or arguing there should be doubt as to his guilt. Confusion among the juries would be the best result we could hope for. The logical conclusion the jurors would come to is he didn't defend himself, and now he's bringing this story to us in a desperate attempt to save his life. The time to effectively establish residual doubt is in the guilt phase, because if you put your defense on in the guilt phase, then when the jury retires to deliberate, they are considering all the state's evidence along with your counter to the evidence, which of course Reginald wasn't allowed to do. And so when they discuss the balance of that evidence, they might find, well, we think the state's evidence does reach the level of beyond a reasonable doubt. However, we are thinking about this defense that was presented to us, and we're thinking about how this defense fits in with the weaknesses in the state's case, the weaknesses in the DNA evidence, the weaknesses in the eyewitness testimony in this case. And because of this defense and how it fits in with the state's case, although we find he is guilty beyond a reasonable doubt, we don't find he's guilty beyond all doubt. And as we've stated before, that area between reasonable doubt and beyond all doubt is where juries frequently find the reason to impose life without parole instead of death.
Are they instructed on some sort of higher burden in the penalty phase beyond a reasonable doubt? Is that what you're suggesting?
No, they don't get an instruction on that.
So
No.
you're speculating as to the mindset of a death penalty jury about what criteria they require in terms of certainty to impose the death penalty? I'm not following what you're saying in terms of beyond all doubt and beyond reasonable doubt. There's some territory in between that the jury kind of lands in for death penalty cases?
There is absolutely. We cited,
Where is that from?
we cited those studies to you in our opening brief, and I can give you the page of our supplemental brief where we cited those studies again. Page 24 of our supplemental brief, the Geimer and Amsterdam study, Why Jurors Vote for Life or Death, Operative Factors in 10 Florida Death Penalty Cases. Garvey, Aggravation and Mitigation in Capital Cases, What Do Jurors Think, from the Columbia Law Review. Also, we've cited a Arizona Supreme Court case in which the court noted that back when they had judge-based sentencing, judges often used the fact that there was some lingering or residual doubt as to the defendant's guilt. It's because juries don't want to make a mistake that can't be fixed. And in light of all the death row exonerations that jurors know about these days, if they have lingering doubt as to the defendant's guilt, they frequently decide, we don't want to be the group that has made that mistake that can't be rectified because the defendant is then executed. I know I'm out of time, but I would like to address Justice Biles' questions about the no adverse inference instruction, if that would be all right, Mr. Chief Justice. Justice Biles, we actually didn't blame this error on the state. I believe what happened in this case was that Jonathan objected. Jonathan didn't want a no adverse inference instruction, and that's another example of the prejudice to Reginald in this joint penalty phase hearing. I would also say that Estelle versus Smith certainly gives a defendant Fifth Amendment rights in any kind of sentencing proceeding.
What's your response to the state's answer to Justice Stiegel's question about the form of the jury instruction that you asked for, since it mentioned guilt phase, and I don't remember if it does, and I would have to dig around here to find it, but that's at least what was said. So the notion is that what you asked for wasn't factually appropriate and probably wouldn't be legally appropriate given that, and if so, then you're over in clear error land rather than having requested the instruction.
With the caveat that I don't have a perfect recollection of what happened here, but I actually don't think they got as far as proposing an instruction in this case. I know in my brief, I believe I pulled an instruction from another case because I didn't have a proposed instruction to work with. I think what happened was there was a mention that they wanted a no adverse inference instruction. Jonathan objected, and the judge said he wasn't going to give it. I could be wrong about that.
Well, if that's the case, and I mean, obviously it's easy to go back and look and see what the exchange was, right, and we'll go do that. But wouldn't that put you in clear error territory, since you didn't actually propose something that the court could wrestle with and rule on? There's just this notion, if you're in clear error land, then the burdens are dramatically different.
Correct. I would argue that the fact that the judge cut them down or cut them off so quickly upon Jonathan's objection relieves us of having to then go proffer an appropriate instruction, because they said we would like a no adverse inference instruction, and the judge just said no there. There was a question about, well, the fact that they got a no adverse inference instruction, I believe it was Justice Rosen, they got that instruction in the guilt phase, so couldn't that sort of help the state in the penalty phase, because the jurors got
Not
that.
help the state, help the jurors understand their role in what they are to consider and how they're to consider it.
I think the fact that they got the no adverse inference instruction in the guilt phase makes it more likely that the jurors thought, now we can use his silence against him. Here's why. The jurors got fresh instructions for each phase, which told the jurors, you now have new rules. So when they got the no adverse inference instruction in one phase and not the other, that conveys the idea that that rule doesn't apply to us any longer. And that's buttressed by the similarities in the instructions that were given. Instruction number 1 in both phases contains very similar my duty to instruct language. Instruction number 2 in both phases contains very similar admissibility of evidence and statements of counsel language. Instruction number 4 in both phases contains very similar burden of proof language. Then we come to instruction number 6. In the guilt phase, that's the no adverse inference instruction, and it's completely missing from the penalty phase. So I think the jurors can recall the similarities in the instructions and go, okay, we're no longer bound by that prohibition against using the defendant's silence against him.
Could you address the state's argument about, or at least their statement that they're not sure how the adverse inference instruction would apply to both the narrowing, to both phases of the aggravating and the mitigating? I'm having a little bit of trouble, I think, convincing myself that it wouldn't apply to both. And I take it from your nod you're agreeing with that, but could you address that?
Well, I certainly agree with that. I'm sure they wouldn't have proposed an instruction that in determining whether the state has met its burden of proof on aggravating circumstances, don't consider the defendant's silence in this case. What the no adverse inference instruction in this case would do is tell the jurors, if you are expecting the defendant to take the witness stand and say he's sorry and express remorse, you can't hold his silence against him in this case. And it would apply more to the balancing, really. The balancing of aggravation versus mitigation don't factor in the fact that the defendant hasn't taken the witness stand and discussed this situation with you. So I guess it would affect everything, and the balancing of those things.
Counsel, I see you're out of time. I'm going to ask, do we have any further questions?
One final question, if I may. I wanted to ask you about the severance of the penalty phase. And you've argued that that's an error under state law. The state has countered that even if that's error under state law, it's harmless. And I wanted to just ask you about the language in the United States Supreme Court opinion. And what are we to do with that? They have opined that it requires extravagant speculation, that it's beyond reason to think that the joint sentencing proceeding was fundamentally unfair. And I understand your argument is that's not binding on us, and it might not be binding because it's either dicta or because it doesn't affect state law. But as a matter of reason, what are we to do with that? Just say they're wrong?
I would say that the United States Supreme Court was addressing the Eighth Amendment requirement of individualized sentencing determinations.
But they're addressing it in this language that I'm citing to you in the context of prejudice. Mm-hmm. And that's the question I'm specifically asking about, because we would have to agree, in order to vacate the sentences on this ground, we would have to agree with you that it was error under state law. And let's, for the purpose of my questions, assume that. And then we would have to also find that that error was not harmless. Mm-hmm. And that's where I'm getting hung up on how do we find in your favor on that, given the presence of this language in the United States Supreme Court's opinion?
always remembering that the federal Constitution provides a floor, not a ceiling, for rights given to the defendants. The United States Supreme Court, as I said, was discussing the Eighth Amendment. The United States Supreme Court was not considering the error and the prejudice to Reginald Carr's state law right, first, to have the jury consider residual doubt, which he is allowed to since we have a non-exclusive list of mitigating circumstances, and his right to be free of jury consideration of non-statutory aggravating circumstances. That's a provision of state law that, while it is not unique, is also not universal. Some jurisdictions allow the consideration of non-statutory aggravating circumstances. And in this case, Jonathan's mitigation case was so antagonistic towards him. The bringing in his mother and his sister, who you would normally expect to say nice things about him, to say it was Reginald who...
But SCOTUS had that information. They had those transcripts. I think the question is, what's the difference? What didn't they have, or what didn't they consider? And I understood you to say earlier they didn't really have all the information that they needed with regard to cumulative error.
Correct.
I understood that to be your response to me earlier.
Right.
Is why the distinguishing aspect as to why we could understand their reasoning but come to a different result.
And then I guess that's my question.
Right,
Do we have to move to cumulative error? If we were only considering what I said for purposes of argument or purposes of the question, we assume this is error. And is it your position that we can't find we can't find prejudice there based on this? We have to go to cumulative error?
No, that's not my position. You know, when I answered your question, Justice Johnson, it was a broader question. Justice Stegall is asking particularly about the penalty phase failure to sever. But I think the failure to sever in the penalty phase standing alone can still establish sufficient prejudice to reverse under state law, particularly because the United States Supreme Court had no idea about the issues with regard to preventing...
You're suggesting that the rights that are protected under state law are different than the rights that are protected under the federal Constitution.
Certainly, because as I said, the federal Constitution is a floor, not a ceiling.
And then, just if I could, a final question then. If we get to this point, do we apply the state law harmlessness test as opposed to the constitutional harmlessness test, which is a higher burden for the state to get over?
I think it is the state law harmlessness test. But to finish my thought, another important factor that played in to the severance of the penalty phase standing alone that the Supreme Court didn't have in front of it was this issue of residual doubt. Because remember, Reginald's ability to argue residual doubt was harmed by the preclusion of his defense in the guilt phase. But then in the penalty phase, remember what this court noted about the evidence that Jonathan brought in, had his sister take the witness stand and say that Reginald had confessed to her. This court found that was one of the things that required severance.
Can I just ask one more quick
Sure.
follow-up?
Sure.
What can you point us to in the law that supports your argument that the state intended to protect different interests than are protected under the Constitution when it comes to severance? And that's the argument you're making, that the state has different concerns. We want to protect different interests.
Well, when
How do we know that?
Yeah, when the United States Supreme Court was talking about severance, they were only talking about the Eighth Amendment requirement of individualized sentencing determinations. We have contended that you already based your decision that the proceeding should have been severed on state law considerations because you...
But why isn't that state law consideration intended to protect the same interests that are protected under the Eighth Amendment?
Because more than just an individualized sentencing determination, those state law factors and considerations are also intended to protect the defendant's right to a fair trial, an overall fair trial.
There's a due process component of the statutory right to severance. Is that what you're saying?
Yes.
Counsel, in response to the question from Justice Stegall, you said that on this issue that you and he were talking about, you would apply the state test for harmlessness. Is that correct? Would you recite that for us, please?
Whether this court can find that there is a reasonable possibility, I believe, that the error affected the verdict. Or probability. I think it's a probability that the error affected the verdict.
And the federal would be reasonable
Beyond
possibility.
Beyond a reasonable doubt.
All right, any more questions for counsel? Thank you, counsel.
Thank you.
We thank both of you for your arguments this morning. I'd like to take this matter under advisement at this time.